I think we can start. We already have a good number of people. Um, Thank you very much, you all, for being here. Welcome to the webinar Prospects for Anti-Corruption Enforcement in Brazil. This initiative is co-hosted by Paul Hastings in the US, Bottini Tamazauskas, and Levi Salomão. It's a pleasure to have you all here. And as most of you are aware, we've been seeing lots of relevant developments recently in anti-corruption enforcement in Brazil. And the point is, this is not only related to Lava Jato, but also to multilateral cooperation in cross-border cases, and especially involving the US and its activities regarding FCPA matters. And this poses challenges to a wide range of stakeholders, including companies who struggle to reach finality when faced with corruption charges or internal findings regarding corruption cases. Also individuals who have to deal with criminal charges, both here and in the US. And it's also a challenge to the authorities who have to do the work in a changing landscape and build a framework and dealing with what is, as expected, a frequent reveal of its practices by the judiciary system. So in order to have the idea of the different points of view of this different types of players, we have 4 speakers here with us today. I have the honor to moderate them, Marcos Malvado with Levi Salomão, and we have here with us Bolivar Rocha, who is also a partner here with Levi Salomão. We have Nat Edmonds, who's a partner with Paul Hastings in Washington. He is a former assistant chief of the Foreign Corruption Practices Act Unity of the fraud section of the DOJ, the criminal division of the DOJ in the US. We have Pier Paolo Bottini, who has also worked in our Department of Justice, the Ministry of Justice. He was in charge of the judiciary reform at the time. And he is now a lawyer with Bottini Tamazauskas and a professor at the University of São Paulo, a professor of criminal law. And finally, we have Eduardo Lage, who is a federal prosecutor in Rio de Janeiro. He used to be the head of the Lava Jato task force until very recently, and he is now the head of the anti-corruption unit at the with the federal prosecutors in office in Rio de Janeiro. And I hope that we can have the 4 of you sharing with us the different points of view for all these players. And I would like to start with Bolivar, who will give us some prospects on how companies, both local companies in Brazil, but also foreign companies with activities here, deal with corruption charges and struggle to navigate the plethora of authorities that we have here in Brazil, and who may impose sanctions for this practices, and also authorities abroad. But I'll leave the authorities abroad for Nat, who will also talk about multilateral cooperation, but ask Bolivar to start with the perspective of the Brazilian side.
Thank you, Marcos. Pleased to do that, and very pleased to be here in such a distinguished company, and we know we have also a distinguished group with us today. In fact, Marcos, if I may, I would like to propose this discussion, which is actually featured in our invitation, which is, are we headed to more settling or more fighting going forward? In light of the recent events in Brazil, the recent setbacks that the Lava Jato or criminal enforcement has been facing in Brazil. My view essentially is that we're going through a turning point, or maybe a point of reversal in that regard. more towards the traditional historical path of fighting in court, and away from the path of negotiation and settlement, which has been so intense and important in Brazil over the past few years, as we all know. And the reason I believe this is the case has to do with the two main drivers for seeking negotiation and settlement, with changes in relation to the two main drivers. The two main drivers being fear of detection and punishment. And the second one, the desire to achieve finality when you negotiate and settle. Now, fear of detection and sanction in relation to individuals, I think this fear has subsided recently. I think it has a lot to do with the recent change in the understanding of Brazil's Supreme Court in relation to imprisonment following a confirmation by an appellate court of a conviction by a lower court. But I'll let Pierre comment on that. There are a few people in Brazil who are more in a better position to comment on that than Pierre. Now, in relation to companies, I think I would say that this driver which relates to with this risk assessment, this fear is clearly still there. There is fear of debarment, what we call inhabilitação in Brazil. The fear of having funds, liquid assets frozen at some point along the way, which is a very concrete concern. So the fear is still there, but on the other hand, in relation to the second driver, which is the confidence that you will achieve finality when you negotiate and settle with authorities, there are strong reasons to be very skeptical, and experience has generated a lot of frustration in this regard, as most of you here today know, and I will not go into many details. It would be a waste of our time. We know that this is not typical, or this is not, this doesn't happen only in Brazil only. I've been learning, and we have had experience and discussions in relation, for instance, with the notion of the prohibition of double jeopardy in the US and the exceptions to double jeopardy. Thank you, Nat. Thank you, Harry Morgan with Paul Hastings for helping me get more educated on this. So this doesn't happen only in Brazil, but it's preposterous in Brazil. It reaches unbelievable levels in Brazil. It is only too often companies who have just settled with federal enforcers will find themselves dealing with renewed investigations by other authorities, federal or otherwise, federal or state, and sometimes municipal authorities, over the very same facts. And again, I'm sure most of you, or many of you, are familiar with this with a problem. In fact, federal enforcers are very aware of the problem themselves. I mean, there have been important articles written by some people may be here with us today. I saw some in the list of participants. But Federal Supreme Justice, Superintendent General at Oecd, former enforcers have been writing about this, recent articles. And more importantly, there was this initiative taken last year, this cooperation agreement entered under the auspices of the Supreme Court, which purports to tackle this situation, purports to bring finality. And the agreement is essentially the authorities saying, listen, the cooperation is not happening satisfactorily. This is affecting the incentives that parties have to reach out to authorities and seek leniency. let's streamline our initiatives, which is very welcome and important, of course. I was a government official a long time ago, and on very few occasions, if ever, have I seen language which is so direct in an official document, acknowledging a problem of this nature, the extent and nature of the problem. Now, the thing is, this cooperation agreement is, I'm afraid, bound to fail. And it is bound to fail because the MPF, Ministério Público Federal, and Eduardo is here with us today and will comment on that to some extent, perhaps. But the MPF chose not to participate, and MPF chose not to sign the agreement, essentially the main reason being that the agreement does not give a formal role to MPF alongside AGU and CGU in the negotiation and execution of leniency agreements. Now, I think that what it would take, and Alexandre Faraco, our colleague, and myself have written a recent piece which appeared on Jota about this, what it would take really to bring improvement, solid improvement to this would, I'm afraid, be statutory change in the applicable legislation to do two things essentially. One, to give MPF this formal role, and the second aspect would be to streamline the competences and the sections that that are relevant in these situations. I mean, this warrants a specific discussion, which it's not would not be a good idea to go into much detail here, but essentially that's what I would need. Now, I'm skeptical this will happen anytime soon. It involves, and it would entail, it would require some authorities giving up competence, power, prestige, space, and so it's difficult. It's complex. It's complex. Not an easy task, and nevertheless, it would be a very important task. But my main point here is in this crucial, terribly important area of criminal enforcement, but Brazil could do with improvement in regard to legal certainty, in regard to efficiency, which is written into the Constitution. The Constitution, our federal Constitution, was amended to have the principle of efficiency written into the Constitution, and also the notion and principle of accountability on the part of authorities. And I'll pause here, Marcos, and I would like later, if we have some time left, I would offer some comments on the background to this very discussion, which is what has been happening to criminal enforcement in Brazil, the setbacks that affect Lava Jato. But we have Pierre on board, we have Eduardo Lage on board, we have Nat, who from the US and as a former federal enforcer knows that his former colleagues at the DOJ, FBI will be asking the question, and how do I go about this now in relation to Brazil? And do I share information? How do I conduct this investigation? But I'll pause here. Thank you.
Thank you very much, Bolivar. It's a very interesting suggestion, and I'm sure that we'll have the opportunities for others to comment on that as well. And before I pass the word on to Nat Edmonds, I would like to invite all of you, all the attendees, to ask questions at the Q&A section that we're going to have at the end. But if for any reason you would rather have your question in writing, you can either send me an email directly, mmalvar@levisalomão.com.br. Priscilla has just written the email in the chat box right here, and I'm glad to ask them the questions at the end if you're not here to do it directly. And now, Nat, please, I'd like to have your views on how the US sees us right now in this changing environment of anti-corruption enforcement, and what you expect in terms of multilateral cooperation involving the US and Brazil and also other countries as well.
Absolutely, and thank you very much for the opportunity to speak to everyone today. I think it's a critical issue, and the world is getting smaller, even though COVID has seemed to keep us all separated. I do think that the world, especially the multi-jurisdictional world, is going to continue. Let me just add on to what Marcos had about my personal background. Obviously was a enforcement FCPA prosecutor for many years, but with Paul Hastings, I've now been with the firm for 8 years. I'm not sure everyone is familiar with it in Brazil, although I think many of you are. We've been involved our team has been involved with a number of different US Brazilian resolutions. We have former prosecutors, we have defense counsel, we have in-house counsel, we've got native Brazilian lawyers as well as US lawyers who are proficient in Portuguese. We've been involved in everything from Braskem to Technip FMC, Embraer, SBM. We've been involved in other internal investigations and compliance projects that aren't public. But with all that as a background, what I wanted to talk about today is really what is the view from the US. What are we thinking about cross-border investigations? What is happening in terms of the future of multi-jurisdictional cooperation? And I want to start with history because I think it's an important piece to kind of understand where Brazil is in terms of anti-corruption enforcement, where US is, because it's not just a US-Brazil issue, it is a Brazil Argentina issue, it is a Brazil-France issue, a Brazil-China issue, and a US issue with all of those other enforcement agencies and countries as well. So quickly, as background, I joined the Department of Justice in 2003. I had my first FCPA matters beginning in 2004. It was a very small group of FCPA prosecutors at that time. And DOJ was essentially operating on its own. There was minimal resources, and there was only formal cooperation, gathering of evidence with other countries. There was no informal cooperation. There was not any coordinated investigations. And that lasted for several years. And then in the mid-2000s, there was some shift. There was some cooperation between the US and Germany for the Siemens case, and then with the UK, United Kingdom, in terms of Johnson & Johnson Depuy, Inaspec, BAE Systems, all major multinational companies, but many of them not based in the United States. What had happened previously was the US would go after not only US companies, but companies around the world, because the local enforcement agency was not enforcing its laws, was not bringing the foreign bribery cases against its own companies. So the US, in some ways, was acting as policeman of the world. And I think that in the mid-2000s, there was a recognition that that was not what the future should be. And there were specific and intentional efforts to coordinate with other law enforcement and prosecutors around the world to bring joint cases for DOJ to develop evidence, turn it over to the other authorities so that they could bring their own cases. And some of that was bilateral, so country to country, US to UK, US to Germany. But there's another aspect of it, which I think is a really important piece to consider, which is the OECD Working Group on Bribery, which is headquartered in Paris. It's a collection of over 40 major economies, as well as who are members as well as observers, including Brazil. And I was one of the US government's delegates to that group for many years. So the working group was established to ensure that there was a global effort on anti-corruption efforts, that there was the laws and legislation that were passed were appropriate, and then the goal looking at implementation, looking at resources, enforcement. So during those meetings, prosecutors from around the world, including Brazil, met to discuss the legislation, the commitments to the Anti-Bribery Convention, but they also started to build trust between the prosecutors in one country, the prosecutors in another. So these 4 week-long meetings every year in Paris, those forged some of those relationships, both between individual prosecutors, but ultimately between the different institutions on different countries. And that led to coordination, that led to cooperation between the prosecutors, between the FBI, local law enforcement, and that has led to these multi-jurisdictional cases. And one of the things that we've seen is that for many years, DOJ would take all of the money, right? There would be an enforcement action against a French company, they would take all the money. Enforcement action against an Italian company, they would take all the money. But with this coordination and cooperation, there was the sharing of the penalties. And that was a huge incentive for other countries to recognize that there are millions, if not billions of US dollars that are at stake. So what we are seeing and what we've seen in the past few years is that shift of the sharing of the money, which is good not only for the enforcement agencies, but there are undoubtedly benefits for the companies that are caught in the middle as well. So I think Bolivar noted what I would say is really a critical component for my clients, right? The certainty of finality. When you're able to reach a resolution that captures all or almost all of the enforcement authorities. That is what the world has been moving towards, these global resolutions. It's good for the companies because it brings finality, but they also do not get penalized twice. And the US has been moving to reduce the penalty that is paid to the US if it is paid to another country. And my recent experience representing Airbus is a good example. This was a resolution in January 2020, one of the largest anti-corruption resolutions of all time. Global simultaneous resolution between the UK, France, and the United States. DOJ deferred to France as the one with the primary enforcement interests. And they reduced the penalties that were owed to the United States by over $1 billion US. And that was based on what Airbus had paid to the French government, to the French prosecuting agency. So those coordinated, those global resolutions with offsetting penalties are beneficial not only for the enforcement agencies, but also for the companies themselves. Importantly, to just follow on what Bolivar had said, right, there isn't necessarily a global framework for that, right? There is no ability to say this has to be done in this way. But ultimately, there is a level of trust between the different enforcement agencies that has been built up over time through the OECD, but also through smaller cases and the informal networks that are built when you investigate the cases. The country that DOJ has done more resolutions with, I believe, than any other is Brazil. They've done it over 10 times, and almost all of them in very recent years. And we've seen this massive increase in coordination with Brazil. It started back when I was in government on the Embraer case, coming out of the OECD coordination aspect of it, but has gone all the way through to recent ones, including VTOL. Some are able to do a global resolution, not only between the US DOJ, but also multiple Brazilian agencies. Technique FMC, which Paul Hastings was involved with, was a coordinated resolution, not only globally, but in Brazil. In each of those cases, there has to be cooperation between the different enforcement agencies. There have to be an understanding and a split of the penalties that go with that. Now, with all that as background, with all that as history, what does that mean for the future, right? What are we seeing from the US, and what is the role and importance of Brazil to future enforcement efforts from the United States? And how does the US interest impact what is going on in Brazil? Well, there are currently 23 active DOJ FCPA cases involving Brazil that are publicly identified. I think that undercounts them significantly. The ones the DOJ is investigating but are not public, or the ones that law firms like I am on, which have not necessarily made the public disclosures when we're advising our clients. But with all the changes roiling in Brazil, and I'm not going to go into those, I will leave those to others to really go into the details. What does that mean for the DOJ's perspective on multi-jurisdictional cooperation with Brazilian authorities? Well, DOJ has not made any statements publicly, and I think that they have been very clear that they want cooperation to continue. But the issues that are roiling Brazil, that are causing challenges to anti-corruption enforcement, may mean less cooperation between DOJ and Brazil. DOJ is undoubtedly looking at what has happened recently with Lava Jato, looking at what is happening in the Supreme Court, including the overturning of the Lula conviction, the decision on the alleged bias of Judge Moro, and think, what does this mean? How will DOJ have a reliable partner with these challenges? How is the international community, how is the OECD going to react? Again, I don't have any specific knowledge of what DOJ is saying, but my perception is if DOJ sees corruption progress being undone in Brazil, if they have doubts about the reliability and commitment of the current administration or any future Lula administration, what would that mean for DOJ? It may mean they may pursue less cases in a cooperative fashion and more independently. They may do more of the hard work themselves, work through the formal mechanisms, share information only when required with the Brazilian authorities, because that is also probably what the Brazilian authorities are going to have to do with the US. Multiple reports in the Brazilian legal press called into question some of this informal sharing of information between authorities. These are the hacked telegram messages from the Lava Jato task force. I'm not opining on them one way or another, but that may mean that prosecutors will only be able to share information through the formal mechanisms, through the mutual legal assistance treaty requests. That limits the ability to share real-time information, coordinate strategy. It will slow down the investigations. It may impact the FBI agents that have been stationed in Brazil to help coordinate some of these Latin America cases that DOJ has been focused on in recent years. All of that means that the cases slow down, the relationships are weakened, each country is more likely to go on their own. And we saw some of that happen between the US and the UK in years because of issues associated with the LIBOR case, where there was conflict between some of the enforcement agencies. And that led to a slowdown, which has recently reemerged as a stronger partnership. But there definitely were limits based upon some of the challenges that the UK was facing internally, as well as some conflicts between the different authorities. All of this impacts what Bolivar was talking about. How do you get to that finality? The companies are in a harder position to negotiate a global resolution if you're not able to ensure that the authorities themselves are cooperating. How do you get the timing of the resolutions? How do you do the sequencing of that? How do you deal with the evidentiary issues, the privilege issues? That's what Global Counsel can do, can bring these types of perspectives on how to manage all of it. And it is much harder to do if there is a lack of communication and a lack of dedicated trust between the enforcement authorities. Again, I want to emphasize DOJ is very strong, has been said very positive things about its relationships with Brazilian prosecutors, Brazilian enforcement authorities. But I would note that the OECD has raised significant concerns about what's happening with Brazil. So just last month, Drago Kos, who is the chair of the OECD's working group on bribery, discussed the establishment of an OECD standing, what they called a monitoring subgroup to look at the anti-corruption efforts in Brazil. He talked about this in an interview with BBC News Brazil. Part of that measure, and Brazil, the government has accepted it, is that experts from 3 OECD countries have been assigned to monitor anti-corruption efforts in Brazil, to look at it to look at an independent basis, having contact with Brazilian authorities, to make sure that there is not a slide back to a lack of coordinated and global enforcement efforts, and that ultimately Brazil can live up to the standards set forth in the Anti-Bribery Convention. Part of it was various legislative changes, some rulings by the Brazil Supreme Court, but part of it was the OECD's stated concerns regarding the perceived push to end Lava Jato prematurely. So this is an international body that is looking at Brazil and asking what is happening. And this is the first time the OECD has adopted such a strict measure for any country. And it's one of the strongest measures that is available to the Working Group on Bribery. And it's something which I think Brazilian companies, Brazilian lawyers should be aware of that this is an unusual situation from an international perspective looking in. Brazil has been given so many acclamations of praise for the work that has happened. And now I think that there is concern from the international community about what that means. So the perspective that I have is one which is the US is very clearly focused on its long-term relationship with Brazilian enforcement authorities. It's been very positive for the enforcement agencies, and it is one which I expect they will do everything they can to continue. However, pressures internally at Brazil, within Brazil, may pose some challenges to that. And these global coordination efforts and the local Brazilian coordination efforts are going to be critical for companies to think through how they want to approach both US authorities on a Brazil matter, as well as Brazilian authorities, because there are many issues that can arise in these types of situations. I'm happy to take questions at the end or now as Marcos, you deem appropriate. But I would say that the view from the US is uncertainty. There has been such a positive relationship between enforcement authorities in the past, and that's worked to the benefit of some companies as they're able to do these global resolutions. But as there is uncertainty within the Brazilian legal framework, that has led, I would imagine, to uncertainty from the US, from the global enforcement community about what comes next and how reliable a partner Brazil will be going forward.
Very interesting, Nat. We already have some questions, but I'll leave it to the end. We invite everyone to ask questions as well, either directly at the end or in writing, sending them to the email in the chat box. And now I would like to hear Pia on the prospects from a criminal perspective regarding individuals, and also Pierre, I would like to you to say whether you think these recent developments are just a fine-tune related to specific cases, or they hamper the ability of the authorities to enforce anti-corruption laws in Brazil. And how do you see that, and how do you expect that to impact the incentives of individuals in criminal cases?
Okay. Good afternoon, Marcos. Thank you for the invitation. Thank you, Bolivar, for the organization of the discussion. I would like to say hello to Eduardo, who is making a great job in Rio de Janeiro, and Nat and Mariana, and Jose, and all of you that are here present. Well, to answer your question, Marcos, I think we should go back a little bit and try to understand why make the car wash, the Lava Jato, this big operation that it was since 2014 and 15. And I think we should understand the basis that allowed the car wash to be as big as it turned into. And so we can try to understand why the operations maybe suffer the attacks that have been suffering these last months. I think it all begins in 2013 when we had in Brazil a new legal frame. There were some bill of laws that were approved that really gave to the prosecutors some instruments to avoid corruption or bribery, or to look after those practices. Those three bills of laws were, first of all, the changing of the money laundering law, that we just made a big change. This was in 2012, but okay. The approval of the organized crime law, and the approval of the anti-corruption law. Why those laws are so important to the fight of the corruption in Brazil? Because they offer to the prosecutors first the cooperation agreement that was bad, really bad regulated in the previous law. We had this cooperation agreement since a lot of years ago, but It was really bad regulator. Now we had a new law with that defined the proceeding rules, the step-by-step for the corporation, and gave to everyone who works in this field more security. And those new laws bring more than the cooperation agreement, the leniency agreement, the company agreement that was not previously regulated in Brazil. And I think that this legal mark made possible the operation car wash. These laws is not, if we see the timeline, we will see that these laws were approved, all of them, in the middle of 2013, and the operation car wash begins in the beginning of 2014. So I think the car wash, the Lava Jato, is not only a good initiative of judges or prosecutors. Of course, the persons were really important on that, but it's to the results of this new legal mark that we had in Brazil that offered instruments to ensure a better fight against corruption in Brazil. So after that, the car wash, the Lava Jato, this operation had a big development in the next few years. And why? First, because the prosecutors made a good use of the cooperation agreement and the leniency. Second, because the judge and the prosecutors, they had a really good communication strategy that helped the car wash gain popular and political support in that time. And this was really important. And third, because, and maybe because of this, the car wash had support of the courts. And when I say courts, I'm talking about the regional courts and the Supreme Court in the beginning. They have this support. There were, and Eduardo can correct me if I am wrong, but there were few court decisions against the Lava Jato Act or sentences in the beginning of that time. So the question of Marcos, what happened? I don't know exactly what happened, but there is a turning point somewhere around 2018. It was the beginning of this bad moment for the operation car wash. And it's really difficult for us all to take any definitively conclusion because I think we all are too close from those facts, from the historic perspective. So we cannot see clearly why, on which reasons, the reasons for this turning point, the reasons for the changing of the mood about the car wash. But what we can see, and is a fact, first, what happened? We can see a changing of the behavior of the Supreme Court when treating Lava Jato operations and acts. The Supreme Court begin to make some judgments against some Lava Jato acts. And I can give a few examples. There are many examples, but since the end of 2017 and the beginning 2018, for an example, the Supreme Court says that it is in Constitution to arrest someone before the end of all the resources, all the appellation until the Supreme Court. After that, the Supreme Court declared that the judge from Curitiba, that was the center of the Lava Jato operation, was not the competent judge to take care of those cases. As we see, this Lula decision is not the first decision in the same way. As you said, Marcos, it's not only Lula. We had a few decisions before that too. And the Supreme Court so got these Lava Jato cases and distributed some to the electoral justice, some to other jurisdictions, as the case of Lula. So I'm just take the example of those two cases, those two decisions, but there were a lot of decisions of the Supreme Court just overruling or just attacking or changing some Lava Jato important acts or sentences. The second fact is the changing of the legal mark in Brazil. If we have the approbation of a legal mark in 2013 that was important to Lava Jato operation, we have in 2019 an important changing of the law in Brazil. In the end, in 2019, the Congress approved a new criminal law that we call the Pacote Anticrime, with some important changes in the cooperation agreement, in the individual cooperation agreement. And I can give you, for example, of those new changes of the law. The new law forbids any prison, any seizure, or any beginning of criminal action based only in the cooperator declaration with no other proof. So the prosecutors cannot use anymore only the word of the cooperator to make a search and seizure, for example. Second, this new law reduces the benefits of the cooperation that can be negotiated. Just to give you an example, before the law, I can go with my client to Eduardo, for example, Oecd, and we could negotiate a cooperation that the prison penalty could be accomplished at home with electronic monitoring. This was really used in car wash. Now, with this new law, this benefit is not allowed anymore. The prison sentence should be accomplished in the prison unit. Of course, that this will reduce the cooperation agreement because it's a few people who wants to make a cooperation agreement and go to the prison unit. You know how the people in the prison unit look the cooperators with justice. So this was a second fact that was this changing of the law. And the third aspect, and I'm just coming to the end, is a changing in the press mood. As we all know, in 2019, a hacker got some messages in the Telegram app between the car wash judge and the prosecutors and a lot of more people. And some messages were interpreted as a close cooperation between judge and the prosecutors. So the publicity, and I don't want here to talk about the value of those messages, but the publicity of those messages changed the press moods, and the big car wash media support just went down. So those are the facts. What comes next, Marcos? And I think we came here to discuss the next steps. What will happen with Lava Jato, and not only with Lava Jato, but with the prevention and the fight against corruption in Brazil. It's really difficult to know. The Brazil judiciary and Brazilian politics is like a kind of a pendulum. We never know what comes next. It's really difficult to predict something. But we lawyers, and I'm saying we lawyers because I think not Eduardo, but a lot of people who are here are lawyers, we must pay attention to those changes and try to understand those impacts in our activity. And what I think, it's difficult to imagine what will happen, but what I guess and what I figure out is, first, cooperation agreements with individuals will be reduced due to these new law restrictions. Leniency, the company agreements will, I think, increase or maybe maintain the same importance, because these instruments, it's not affected or was not affected by this new law or this new Supreme Court decision. So what I can guess, the fight against corruption in Brazil will continue, especially in the states like Rio de Janeiro with Eduardo. So the task forces in the state, they will still getting on with the investigations, but they will have less cooperation, person cooperation agreements. The companies will still make the leniency agreement because the leniency agreement was not impacted by all these these changes in the law and in the jurisprudence, but I think the cooperation agreement will really be reduced. Então, to tell you, Marcos, and to conclude this first conversation is what I think. I think these new changes, and it's important to know, is not only the changes in the Supreme Court. There are changes in the law too. They really affect not only Lula case, not only that case, but they affect the whole fight against corruption in Brazil. There will be changes in how things are going on in Brazil. Some things will stay as they are, like leniency, but in the other hand, the cooperation agreements will really be impacted with these new changes. I guess this is my contribution to this discussion, and I'm really want to hear all of you and answer all the questions that we can. Thank you very much, Marcos.
Thank you very much, Pia. That was really interesting, and we have now Bolivar mentioning efforts of the authorities in Brazil to negotiate agreements with companies together, and that has some way to go still. Nat mentioned the perception that the Brazil made steps back maybe in corruption fight, or at least there are points of attention here, and the praise that we received in the recent years might not be renewed moving forward. And Pierre mentioned not only Supreme Court decisions, but also changes in the law. I'd like to ask Eduardo how all of this very challenging landscape for corruption fight in Brazil hampers or improves the ability of prosecutors to do their job and fight corruption here, and what are the prospects moving forward under this new after all those changes that we've seen?
Okay, thanks, Marcos. Thanks, Bolivar, for the invitation. It's a great pleasure to be here with you guys and to discuss those important matters and subjects. Well, I think that the prospect for the fight against corruption in Brazil is really bad and really sad. Some years ago, I would say that Brazil is in a good moment. We are listening to the wind of change, and we now have a new moment. But nowadays, I'm not so confident about the future and how things will go in Brazil. For those who are not Brazilians, just to feel a little bit of the sense, investigators are being investigated nowadays. It's not prosecution, it's persecution. Pierre was talking about some laws that were enacted very recently. And one of the laws is the law against abuse or misuse of powers. And the Article 25 of the law says that you cannot use illicit evidence in order to investigate or prosecute a crime. And nowadays, the president of a very high court, the STJ, is using those hacking messages in order to investigate prosecutors and judges. He's brazenly committing crimes, especially within the Article 25 of the law. And so for someone who is a public servant or a prosecutor, it's very demotivating to be in an environment like this and try to pursue and try to continue the fight against corruption. But we'll move on. I am 40 years old. I grew up in a country where corruption was all over the place. I watched the news in the 1990s, and the corruption scandals always went unpunished. All of the Brazilians knew this reality. And after 2013, especially after the protests and the laws that Pierre mentioned, we saw a huge movement, not only in the legislative branch, but also in the society. The society was claiming for change. It was nothing about only prosecutors, judges, and new laws that were enacted. There was a feeling in the society that something must be done. And something was done. After 2014, this huge operation, the car wash, started in Curitiba. And suddenly we unveiled this mass number of corruption crimes that were committed. We have companies that were paying bribes to half of the Congress. And it's literally the half of the Congress was receiving cash and money in offshore accounts, in cash here in Brazil. So everybody was astonished of the degree of corruption that we have reached. Nevertheless, everybody knew that it always happened in Brazil. When we unveiled the number and the scale of the crimes, everybody was very astonished. And unfortunately, after 2018, we have these huge setbacks, especially from Congress and the Supreme Court. We have some very bad decisions from the Supreme Court, and I could mention the possibility of the non-possibility nowadays of imprisonment after the appeal. That was a very significant move from the Supreme Court. So nowadays we have someone who is being investigated only goes to jail after 4 sentences. The Supreme Court has to judge and has to assess his case so he can go to jail. So of course, this creates a huge and great impact on the possibility of negotiation of agreements. And I say collaboration agreements and also leniency agreements. In this point, I disagree with Pierre. I think that the leniency agreements will also suffer. They are already suffering a huge impact. And in my activity, I feel how the mood completely changed. In 2017, 2018, we had a very large number of people, of lawyers and people trying to negotiate agreements with us. And nowadays, this is very rare. The number of people who are trying to negotiate collaboration agreements or leniency agreements is very reduced, especially because they do know that if they hire a good lawyer, they will never go to jail. They will not face any sentence. We have cases here in Rio where the president of a state-owned company, he had millions and millions of dollars in a Swiss accounts. Guy is a public agent. The bank account was under his name and under his daughter's name. And he did not make an agreement. He's already 80 years old, and he knows, and I do know, that he will never face any sentence. And so the system is designed for not work well. So nowadays, the legal framework does not help. The Supreme Court is issuing decisions after decisions against the car wash operation and cases involving corruption mainly. And the prosecutors are being persecuted. So this is the worst of the environments. I hope that the OCDE and the international community look at us. I know that there is some movement occurring, especially in the OCDE. And I hope that the movement and the international pressure really make some impact and cause some result in Brazil, because if we keep on this pace, if we keep on this track, I don't see a very bright future, not only for the prosecutors, but for the whole country, because if you don't have if a foreign company is trying to enter the Brazilian market, which kind of incentive does it have if the company knows that he has to pay bribes in order to gain contracts, and the Brazilian companies are paying bribes and being unpunished? So I know that my message is not very happy, and I wish it was different. In past opportunities, I gave different speeches, but nowadays the situation is not the best of all time. So I am happy to discuss with you guys and to address some of the questions that the attendees may have. Thanks.
Thank you very much, Eduardo. I believe we have different views from different backgrounds after the four of you haven't spoken. But there's a point in common that all of you acknowledge that a lot has changed, that have been some setbacks in terms of perceptions, incentives for companies to settle, to cooperate, for individuals to enter into agreements. And this seems to be with more or less optimism, common perception among you all. And we have already received some questions. Felipe Roquete, who works with CADI, and CADI plays an important role in this fight against corruption as well, because often corruption is linked to public bids, and for the scheme to work, there has to be a cartel in place. It's not always the case, but sometimes it is. And CADI has developed the system with the help of Felipe, which is the brain system to identify these cartels in public bids. And he asks, he congratulates you for the webinar, and asks whether if there's lack of empirical analysis on the results of the car wash operation. He believes that the analysis are all too partial and very emotional, I think. And do you know any study in this regard that gives us the analysis maybe with some distance from the facts? As Bolivar said at the beginning, there's a lot of passion and emotion related to it. So maybe Nat, do you see anything being discussed about the net effect of Lava Jato from those who are outside Brazil, maybe at the OECD? Eduardo, Pierre, I invite you all to comment on that as well.
I'm happy to start and then let others give their thoughts. I think what the OECD is looking for, and what the US is looking for in many ways, are reliable partners on the enforcement efforts. And that is what DOJ has found with a number of enforcement agencies in Brazil for many years. I think the situation that Eduardo described, some of the other pieces, the decisions that have been made, and the uncertainty of it all is creating challenges for what those relationships, what those partnerships will be. And my own experience has been, when there is a lack of enforcement at the local level, the US will try to step up. Sometimes that means that they will do it on their own. So they will bring charges against Brazilian companies if the Brazilian prosecutors will not. They have done that in Germany, they have done that in Italy, they have done that in France, they have done that in Spain. And that question of how do you find the right middle ground with an uncertain legal market, with uncertain legal regime, with an uncertain enforcement strategy, is one which is extraordinarily challenging, both for individuals and for companies, and for the legal advisors that are there. I think it's important to recognize it's not Brazil is not operating in a vacuum, right? All of these legal challenges are being looked at from around the world, are being evaluated with respect to Brazil's obligations to international treaties and to the long-term relationships that Brazilian enforcement agencies have built with DOJ, with FBI, and with others. And I think the overriding principle for DOJ is not to let corruption go. And if an enforcement agency is not able to bring it on its own in the local jurisdiction, DOJ will step up to do that. If they have the resources, if they have the jurisdiction, but that's at least some of my perspective from the external piece. I don't know if that quite answered your question, Marcos, but happy to give that perspective.
Yeah, it was Felipe's question, but I think you addressed it in a very interesting way. I don't know if Eduardo, Pierre, or Bolivar want to comment on that as well. We have at least two or three other questions that we have received. And also all those who want to ask questions directly, feel free to raise your hand in the Zoom configuration, and we can make a round of questions after that. Also there's a question to Eduardo Olage from Rogéria Jeremek. She asks, it's a very easy question, Eduardo. Do you think that there is a solution for a country regarding anti-corruption? And what is the solution? Let me add to that, because that is a question that goes along with another one that we have received as well, which is, do you believe that for us to get back to that perception that we do fight corruption and do not accept corruption practices in Brazil, what has to change? Is it about statutory change? We have to change the law, or we need to build culture and change the practices, how we read the law, the interests, the structure of our system?
Okay, great. So I think there is a solution, but I am not naive to the point that to think that the Lava Jato operation could change the country or could vanish corruption in the country. It cannot be that naive. I think that was a very important step towards a society free of corruption or with tolerable levels of corruption, but we cannot be naive that corruption would be over after Lava Jato. No, I'm not saying that I was intending to vanish corruption out of the country. What I'm saying is that the setbacks that we are facing are completely out of the bounds that could be acceptable. I do agree with Pierre when he says that there is a pendulum, and this is a very common movement throughout all the societies, all the international world. This is completely normal, but the setback that we are watching and suffering nowadays is way out of the what we could accept. I mean, people who were public servants being persecuted and being investigated with the use of hacking messages, recent decisions that are very hard to justify. So I think that corruption we can fight it. I think it will take a lot of time. It will not happen in one generation. It is a very long-standing fight, but I think that society has to change its view and has to be with the public servants in this fight. Now, regarding the other question, I think that we could have a very significant change in the fight against corruption if we have enacted one single law. Let's not say about the 10 medidas, 70 other laws. I think that only one law could really make a huge impact in the investigations and collaborations and with a number of aspects, is the possibility of imprisonment after the judgment of the Court of Appeals. If we could enact this single law, which is totally reasonable, we could have a huge impact. because people who are already sentenced in the first degree could see a light in the end of the tunnel, and they could see that they could go to jail. So there is a real possibility that they will face the law. So I think that this only one change could make a huge impact. And I don't think that this is a very, this is not an arbitrary change. And all over the world, we have laws and systems that allow us to have a sentence, a penalty after a second degree judgment. So I think that I think the society and Congress could make efforts to change the law with this single measure.
Marcos, if I may jump in here, I also like the image of pendulum that Pierre uses. It's a very important one. Difficult not to remember or remind us all that in that connection that the President of the Republic himself, in justifying or commenting the end of the formal Lava Jato task force, said that, and I quote, "I'm not going to end the Lava Jato task force. I have already done that, and this is because corruption, there is no longer corruption in Brazil." Difficult not to remember that. I agree with Eduardo that one could not overemphasize the importance of this change in the understanding of the Supreme Court in relation to imprisonment following a decision by an appellate court. There is draft legislation in Congress in this regard. Some claim, and this would be an interesting discussion from a legal technical viewpoint, but some claim that this provision in the federal constitution cannot, it's a clausula petra, cannot be changed. It's among the fundamental rights. In any case, it's a discussion of great practical impact. And I do think that my personal view here is that it would make sense to make this change. It would make sense because the fact is that, as Eduardo comments, there are numerous possibilities for defendants who have the means to have protracted judicial discussion of criminal matters for a very, very long time. Quickly, my final comment here is that I also think I also not only think, but I see as we handle matters here at the firm, and we see clients and we assist clients with this assessment, increased skepticism and more thorough analysis of whether to go in and self-report in light of the change of not only mood, but change of applicable law and case law. So I think that this is already having an impact in terms of leniency agreements as well.
Pia, sorry, I was in mute. You said you may go. You're on mute now.
Sorry. Okay.
All right.
Well, just to try to, of course, it's really difficult to answer Rogeria's question about if there is a solution to our country regarding anti-corruption. But I think we are discussing here two facts that impacted the anti-corruption works in Brazil. One is the jurisprudence, so these recent decisions from the Supreme Court, and the other one is the change of the law. I think, and if we look closer to that the solution, fortunately or unfortunately, the solution is a political solution, because the nomination of the judges of the Supreme Court, the nomination of the general attorney, the PGR, Eduardo, you know how important it is the people who occupy those places, who make those nominations that have great impact in all of these matters is a nomination made by the president. So the solution, I'm not saying that the solution of the jurisprudential problems are in the hands of the president. But the president, when he nominates some judge from the Supreme Court and the general attorney, the PGR, of course, he is interfering in all of these works that we are discussing. More than that, on the other hand, the changes of the law, the solution in the law, and I personally disagree with Eduardo in this change of the law about the prison after the second judgment. But this doesn't matter now. The point is, we all agree that we need to change the law to make some improvement in the law. And the law changes is in the hands of the Congress. There are politicians too. So I think we will not improve and solve all these questions in the judiciary field if we not discuss in the political field. What I mean with that, we must, when we begin to discuss the presidential elections, and we begin to discuss about the candidates to the presidential elections, we must ask them. And then when I say we, the juridical community, because all of us, we are worried about the anti-corruption. Okay, even criminal lawyers, Eduardo, we are citizens too, and we think that we must improve. And so we must ask these people who want to go to the Congress, who want to go to the presidency, what are their plans about the fight of the corruption? What they're planning to do? What kind of laws they propose to do?
In 2018, the society asked for change. The society voted for change. The society chose the candidate with this mindset. And look the world that we are living in. So it's hard to.
Yeah, but that's it. But I was just talking. We must do it like seriously, you know, like just ask the candidate, not that he wants to change everything that is on there, but ask him how he will do it. What is his concrete proposal, inclusive to the congressman? What kind of law do you think is important? We look, you from the prosecutors presented some proposals, the 10 medidas. We must do that. We can agree or disagree in some points, but I think we should begin to propose those kind of things to participate of the political discussion, because I think that the change, this pendulum, is a political pendulum, not a judiciary pendulum. I don't think that suddenly the Supreme Court reflected about the juridical system in Brazil and just changed their mind because they technically think that the prison in the second degree is constitutional or not constitutional. It's the politics that change all of this. I tell you, I don't understand still yet what was the turning point, but I can assure there is a political turning point and not a juridical one. So I think we should look upon that just to try to understand and try to discuss how increase this fight against corruption in Brazil.
May I add a quick comment here?
Go there, Oliver.
I've recently took part in a discussion where Eduardo was present as well. We had the privilege of Eduardo there and today again, and I realized that I appreciate your candidness, Eduardo, and frankness, and it's obvious that you are that you don't see the very bright prospects, and that you're personally, if that's my impression, that you're personally affected by what's going on, and we all appreciate that. I couldn't agree more with Pia with respect to the importance of democracy as if in a nutshell of democracy. This is where the possibility of change lies. The alternatives are much worse, we all know. There are reasons for skepticism too in relation to the democratic game or to how well this could work, because again, as Eduardo has commented, we know that the incentives for the incumbents in Congress incentives not to promote change with respect to very sensitive matters is enormous. And we also know that the electoral rules in terms of campaign financing, for instance, make it difficult for a significant renewal in Congress to take place. Still, that's the realm, that's the ambience and the environment under which there's very important and serious discussions that, like the ones that relate to the matters we're discussing here today, that they should take place. I share your frustration, Eduardo. This was very present in the latest presidential elections. Well, 2022 is right around the corner, and it will be time again to discuss and to claim this and to demand this from our representatives yet again.
Mariana, I think you have a question as well.
Oh, thank you. Sorry, apologies for the background noise. First, I'd like to thank and congratulate the speakers for such great and thought-provoking interventions. This has been very educational discussion. Well, two quick comments / questions. First, on picking up on Pierre's, Bolivar's, and Eduardo's thought about the pendulum. I wonder, well, not to deny that there are serious issues at hand. I'm not going to go through them again, but I wonder whether the fact that and Eduardo touched upon this as well, that whether this isn't part of isn't at some extent at least part of what's a movement that is going on globally. There have been discussions with respect to leniency agreements, the challenges faced with respect to leniency agreements in other fronts, such as the antitrust front, cartel enforcement front, the fact, and this has to do with also the incentives for leniency in that front as well, whether this hasn't to do with this global challenge with respect to anti-corruption and also cartel enforcement. So this is one thought / comment, and this also has to do with a comment that Felipe made, and Marcos made reference to the BRAIN project in response to the fact that there hasn't been so many leniency applicants in the cartel front. For example, agencies have taken steps to strengthen their investigative tools. This is a challenge, and maybe it's part of the solution, not also for cartel enforcement, but also for anti-corruption enforcement. The second thought / question is whether this all may sound like wishful thinking, but it isn't. But I wonder whether the fact that there are strong institutions, so there is the MPF, CGU, AGU, which have done a terrific job for a number of years, and there is knowledge that has been accumulated over this time. Whether the fact that there is this and also other strong institutions such as CAGI and the CVM that are also using their strong investigative tools and have strong severe sanctions to apply, whether this isn't an indication that this is a part of a pendulum, and that it will, following the elections, possibly go back to where it was a few years ago, or more like maybe a spiral movement, and going down and going up again with some as part of a learning curve.
And Mariana, before they answer your question, I'd like to make another question that came from Deckard in Paris, from Gabis Latifan, which is related to what you said about the forthcoming presidential elections. He asked whether it could be expected that corruption investigations are launched in order to undermine some of the candidates in the forthcoming presidential elections in Brazil. The use of criminal law for political gains. This may be related to what Pierre said, that it's a matter of politics, and what you said, it's a political pendulum. So if you could, as we are running short of time, we'll answer all the questions together, it would be good. I don't know who wants to start. It was...
Yes,
Eduardo, on politically motivated investigations?
Yes, no, yeah. Politically motivated investigations are a completely abuse of power and misuse of the institutions. We cannot admit this. I know that in the recent past this has happened, but of course, no one could admit or agree with this kind of practice. I would like to touch on a point that Mariana raised, is regarding the knowledge that we have acquired during those last years. So this is a legacy of the operation. I think that all the prosecutors and policemen and investigators, such as Felipe Roquette that works at CADE, all of us acquire a huge knowledge throughout those last years, and this is a legacy that no law or no Supreme Court decision can take out of us. So this is something that we will remain, and I hope that in a near future, when we could find a proper environment, we could put those put this knowledge in practice in its full power. So this is the bright side of the whole thing that we have been experiencing. And I hope that in the near future, we have a better legal framework in order to fight corruption. And just one last point before passing the word regarding what Pierre told about how the politics are important and how we have to vote for better change. I have a friend of mine that he says, all we need in Brazil are 7 people, 1 general prosecutor and 6 Supreme Court justices. That's it. If we have 1 general prosecutor and 6 people in the Supreme Court, doesn't matter the law. You can have any law that you want. It's constitution, unconstitution. You can do whatever you want. We are watching here now in Brazil, the Supreme Court is investigating people. Anything goes. If you have 6 people and 1 general prosecutor, you can have the Congress that you may have, that things will work and things will move forward. So this is my final message, and I would like to listen from the other speakers.
Actually, I'd like to put forth a question, or perhaps two. The first would be to Bolivar. In the first place, thank you very much for these very insightful presentations. The first question to Bolivar regarding means in which a company approaching the government for leniency might strive to achieve finality in its dealings. And the second to Mr. Oecd, that very kindly agreed to be with us, whether there is any kind of restraint from the prosecutors or lack of it that might have contributed to a better outcome in the car wash investigations, especially considering that Mr. Oecd's results, as far as I see them from a distance, and he was throughout a very restrained and technical prosecutor, tends to be very above average in relation to results and to showing guilt of parties. And this may have lacked in certain prosecutors. But this would be my two questions.
Thank you, Eduardo. If I may, just quickly, I commented on finality. It is a difficulty of very practical impact, which may amount to a big disincentive to companies contemplating settlement. And if I may echo Mariana's thoughts, I think that I like the notion of the a solidez das instituições. I think that has very concrete translation, and despite the discouragement that one such as Eduardo may feel presently, I agree that the work that has been carried out by not only MPF but AGU, CGU, and other enforcers tends, in fact, to be resumed with renewed determination once this pendulum moves again.
That's the problem, Bolivar. But what would be the way out for a client interested in going forward? Is there?
The way forward really has to do with analyzing the specific risks and specificities of the case, balancing, weighing pros and cons, and the risks in the short run of debarment, of getting assets frozen, or of someone else going in and self-reporting, weighing that against the alternative, which is just to fight problems and investigations if they come up. In a nutshell, that's what I would say, Eduardo.
Okay, thanks, Eduardo, for the kind words. It is a pleasure to be with you guys here today. And I do agree with you that some restraint would be necessary. I'm not saying that the operation has not committed any mistakes. It's not what I'm saying. I do acknowledge that the operation has committed some mistakes, has sometimes stepped out of bounds. I know that we have to correct this in further operations or in our internal affairs. But what I see from my point of view is that the setback, it's excessive. We could make those corrections within some restraints. So this is what I think about. And just to be clear, I'm not undermining the power of the institutions and democracy. I do believe in Congress, in the elections. But unfortunately, here in Brazil, the Supreme Court has a supreme power. So it runs completely out of control. The Senate does not exercise its powers regarding the Supreme Court, maybe because of fear, but the mechanism of balances and freios and contrapesos does not work properly in Brazil, in my point of view. So I think that the core issue is within the jurisdictional, institutional, and maybe if we could make some kind of correction, we could have a better system.
Thank you, Eduardo.
Well, I know that these are very interesting topics. Sorry, Eduardo.
I was just thanking Eduardo and Bolivar.
Thank you for the question as well. And these are all very interesting topics, but we are mindful of everybody's time and committed to stick it to an hour and a half. Although we could certainly go on for hours discussing. So I invite Pio and Nat to make their final comments, and as we reach the end of the event, please.
So I'm happy to comment. Thank you very much, everyone, for the opportunity to speak with you. I think that these are very important discussions to have, given all the progress that has been made and some of the challenges that Brazil is facing now. I would just say I remain perpetually hopeful that there are opportunities for the legal systems to work together and to find solutions for all those involved, for the government enforcement authorities, for the companies, for the relevant individuals and council. I think that the challenge of conflicting or inconsistent laws and enforcement is an extreme challenge for all of us. And I think that that's something we should all be trying to figure out how we can contribute to and try to smooth the way. But thank you very much for the opportunity. I've learned a lot about this, and I very much appreciate the chance to see all of you. And I hope that we can do another discussion at some point in the future.
It was definitely our pleasure, Nat. We learned a lot with you today as well.
Marcos, I just
Yeah.
want to thank you all again. I think, Nat, that you said the right word is challenge. I think challenge is the word that represents what we are facing now in Brazil. And I think that the way to get over it is this way. And so we sit down, the prosecutors, the criminal lawyers who want to discuss it seriously too, and the administrative lawyers, the judges, and we try to understand what's going on, because we still could not understand really the reasons that exactly what's going on, and try to find concrete steps to move on. So I think we can face this challenge, but we can do it together. So that's why I want to thank Marcos, Eduardo Salomão, that I could not have the opportunity to say hello to you, and Mariana Bolivar. Thank you to organizing this discussion, and thank you for inviting me too.
A pleasure to be with you, Pierre, and thank you for the very interesting speech.
Yeah, so as we reach the end, I'd like to thank all four speakers, and especially all the attendees, not only for the questions that you made before the time. Hopefully, this will be just the beginning of thoughtful discussions that we might have among all those interested in this topic. And we look forward to many other events where we can candidly discuss and certainly improve the corruption fight in Brazil, the US, and the discussion of these topics. Thank you all very much.
Thank you, Marcos. Thank you, everybody. Bye-bye.
Thank you, everybody.